Hello everyone. In this video, we are going to discuss penal liability under jurisprudence. The theory of penal liability is concerned with the punishment of the wrongdoer. It can arise either from a criminal or a civil wrong. As regards the condition of penal liability, it is expressed in the Latin maxim actus non facit reum nisi mens et rea. This means that the act does not constitute guilt unless it is done with a guilty intention. That is to say, there must be two conditions to be fulfilled before fixing penal liability. First is actus reus, that is wrongful act, and the second is mens rea, that is guilty intention. We can say that act plus bad intention is equal to penal liability. The first condition is the actus reus or prescribed act. Salmon called it the physical or material condition of liability. A person cannot be made liable without any wrongful act. For example, a person took a book from a library intending to steal it, but finds that it is his own book. He has committed no offense, though he had intention to steal a book. Justice Bryan rightly stated, "The thought of a man cannot be tried, for the devil itself knoweth not the thought of a man." The second condition is mens rea or bad intention. It is the formal condition of penal liability. An act is punishable only if it is done with intention. For example, act done by a children under 7 years of age does not constitute criminal liability because children under 7 years of age are considered doli incapax under Section 82 of Indian Penal Code. It means they are incapable of forming the intent to commit a crime. Likewise, under Section 84 of IPC, nothing is an offence which is done by a person of unsound mind. Examples of penal liability: liability to suffer imprisonment. Court may order that a person who is convicted of murder to be punished for life imprisonment. Liability to pay fines. A person who has violated traffic laws may be made to pay fines. The measure of penal liability. There are three ways to measure penal liability. First is motive of the offence. Second, magnitude of the offence. Third, character of the offender. Motive of the offence. As regards the motive of the offence, the greater the temptation to commit the crime, the greater should be the punishment. The object of punishment is to suppress those motives which lead to crimes. The stronger these motives are, the severer must be the punishment in the case. If the profit to be gained from the act is great, the punishment should also be severe proportionately. For example, if one had motive to kill anyone, the punishment would be given accordingly. But if a person gained great profit from the act of killing, the punishment would also be severe proportionally. A good motive, though, is not a defense against conviction. It may provide some leniency or a lesser punishment is awarded. For example, theft of food motivated by hunger. Consider the condition of the accused who had not eaten in days, that he or she felt it was necessary to steal the food due to severity of his or her hunger, or even due to malnourished. In such case, the accused will be punished for stealing, but he or she may get some leniency. Magnitude of the offense. The second rule for the measurement of penal liability is the magnitude of the offense. The greater the magnitude of the offense, the greater should be the punishment. The greater the mischief of any offense, the greater is the punishment. The greater punishment is profitable to inflict with the hope of preventing it. If the punishment does not vary with the magnitude of the offense, there will be a temptation to commit offense of very serious nature as the punishment is the same in both cases. For example, if punishment for burglary and murder were to be the same, the burglar would not stop at a lesser crime. How much profit a wrongdoer gets by committing a wrong is seen in measuring penal liability. If the wrongdoer gets more profit, the intense punishment will be followed. Character of the offender. The character of the offender should also be taken into consideration while determining the measure of penal liability. The worse the character or disposition of the offender, the more serious should be the punishment. The law imposes upon habitual offender penalties which bear no relation to the magnitude of the offense. The most degraded criminals are said to exhibit insensibility even to physical pain. Many murderers of worst type show indifference to death itself, so it is desirable to punish more severely the more corrupt. Thank you for watching this video on penal liability.